Thank you, Madam Speaker. Honorable Senators, I rise to speak to Bill C-15, which deals with the UN Declaration on the Rights of Indigenous Peoples. I'll begin with the words of Joséphine Bacon, an Innu elder woman, a poet, filmmaker, and member of the Pessamit First Nation, in the recent film Je m'appelle Humain, or My Name is Human, directed by Kim Obamsawin. I quote her, "I don't have a feline gait. I have the back of my women ancestors. I have the bowed legs of those who bore, of those who give birth while walking." She continues, "I made myself beautiful so that the marrow of my bones would be noticed. I'm a survivor of a story that has not been told." This First Nation occupies a reserve on the St. Lawrence River on the North Shore, part of the region that later became the division of Les Laurentides, which I represent here in the Senate. I'd like to thank our colleagues on the Indigenous and Northern Affairs Committee who analyzed the bill and heard a great deal of testimony reflecting many perspectives. Bill C-15 was passed in the other place on May 25, and that was preceded by Bill 262, introduced by MP Romeo Saganash, which I supported, but which died on the Senate order paper in 2019. In the election campaign that followed, the government committed to bringing it back, which it did in an amended version with the introduction of Bill C-15, which is before us. I want to emphasize that this bill did not come about by accident. It's the result of decades of hard work by Aboriginal peoples in Canada and in other countries for the recognition of their fundamental rights. I just want to give you a single example of this hard work in which I took part directly while I was pregnant with my eldest daughter. The appearance in 1997 by Innu and Atikamekw chiefs, accompanied by their witnesses, Innu and Atikamekw hunters, whose testimonies were translated by their interpreters before the House of Commons Standing Committee on Indian Affairs and Northern Development. They spoke to oppose Bill C-9, which would have expropriated their traditional lands, and this was contrary to the principles of law regarding expropriation and in contravention of Canada's and Quebec's constitutional obligations to recognize and obtain permission of their rights before carrying out any work in these areas under the Quebec Boundary Extension Act of 1912. The Innu and Atikamekw First Nations also took the issue beyond our borders. They took it to the Russell Tribunal in Rotterdam in 1980, which examined violations of American Indian territorial rights. Then in 1985, they took their case to the authorities of the working group created in 1982 by the UN Subcommission on the Prevention of Discrimination and Protection of Minorities to examine the situation of Indigenous peoples. Their determination and that of other Indigenous peoples eventually reached the UN, where work began in the 1980s on the rights of Indigenous peoples living within state borders. So we are here today to discuss the rights of Indigenous peoples, and Bill C-15 has two purposes, as many of my colleagues have said. The two purposes are set out in Section 4. I'd like to state that Section 4 and the preamble would enshrine UNDRIP into Canadian law in the wider context of economic, social, and other laws, which are also contained in international legislation. I would also like to say that that Section 4 is directly aligned with the exclusive jurisdiction of Parliament, which is in Section 24 of the Constitution Act 1867, and which applies to Indians and lands reserved for Indians. Again, it's known that the courts have clarified over the years that exclusive federal jurisdiction over Indigenous peoples includes, in addition to First Nations, Inuit, and Métis. Articles 5, 6, and 7 differ from Article 4 in that they create obligations, two types of obligations. one for the federal government, and a series of obligations for the federal minister who will be designated as the minister responsible for the implementation of the law by the federal cabinet. Now, so this first obligation would trigger a major legal review of federal laws, and the second set of obligations is imposed on the minister responsible. The minister would have to develop and implement, in consultation with Indigenous peoples, an action plan to achieve the objectives of the declaration, and 3 types of measures set out in Section 6 will need to be incorporated into this plan. First, it calls for the elimination of all forms of violence, racism, and discrimination. Second, there would be measures for monitoring, oversight, and reporting on the implementation of the declaration. So this would also be part of the action plan. Any other measure could also be contained in the action plan. The plan would also have to have follow-up provisions and would also allow for amending the plan where necessary. And then there would be a review of the Act 2 years after it's coming into force. So there are different types of obligations, including an obligation of accountability. So the minister would have to table the action plan in Parliament and then prepare an annual report within 90 days after the end of each fiscal year on the measures taken and on the implementation of the action plan. And this report would be tabled in each House of Parliament.
Honourable Senators, it's our responsibility to hold the government accountable for how it will fulfill this obligation. We will have the opportunity and the responsibility, and I emphasize this aspect of our role, to analyze in detail the action plan and the annual reports tabled in Parliament by the designated minister responsible, as provided for in Clause 7. And not only will we have to review each annual report, we will also have to analyze the changes in the compliance analysis over time, as it is expected that this legal review process will take several years. The real accountability of a government lies in how Parliament, in our case the Senate, fulfills its responsibility to hold it to account on an ongoing basis, especially in this case where it is known in advance that the work will take place over a number of years and that it must be directed at specific objectives. The interpretation of Indigenous peoples' rights must no longer be left to the courts without guidance. In this sense, UNDRIP will explicitly provide guiding principles on which courts will have to base their decisions. The last 39 years have been marked by a government strategy or inability of successive governments to reach a consensus on the scope of the constitutional rights recognized and affirmed for Indigenous peoples in 1982. The net result is that the political field has left it to the courts to decide piecemeal as disputes come before them, which is socially and economically counterproductive, in my opinion. Indigenous peoples are the ones who directly pay the price. But you can also say that the whole population pays the price in terms of delayed projects, blockades, if not violent incidents for which both Indigenous and non-Indigenous people pay the price. The political stalemate has persisted until now, and court decisions on the constitutional rights of Indigenous peoples have not led to legislative change, which means the exercise of these rights is still suspended, as we have seen again recently. Honourable Senators, if a real Truth and Reconciliation initiative is to be launched in response to the repeated calls by the Truth and Reconciliation Commission and the National Inquiry into Missing and Murdered Indigenous Women and Girls, it is incumbent on us as legislators, to ensure that the framework provided by Bill C-15 is adoptive, if only to remind ourselves of the real extent of work that remains to be done. Canada must commit to the transitional justice mechanism of a Truth and Reconciliation undertaking. The work documenting the truth must be completed, and the truth thus uncovered must be recognized. These two conditions are the basis of reconciliation if we are actually serious about it. Otherwise, we are asking Indigenous peoples to reconcile with each other, which is absurd, or asking them to reconcile with us when we do not want to acknowledge that the truth has come to light. We know that there is no unanimous support among Indigenous peoples around Bill C-15. I hope, colleagues, that none of us is surprised by this. The great diversity of Indigenous cultures, but also the huge variety of legal situations for the various communities, even within the same nation, means that some of them may, for political and legal reasons, not wish to change the legal status of their relationship with their state, which may have been acquired after years of arduous on-the-ground negotiations. Other communities might feel that the implementation of the Declaration does not go far enough to protect them. Article 32 of the Declaration has attracted much comment and has almost overshadowed the other provisions. It has to do with free, prior, and informed consent of Indigenous peoples. It deals with the development and use of Indigenous peoples' lands or territories and other resources. I'd like to draw your attention to that under our current regime, the state must consult and cooperate with Indigenous peoples, which has already been enshrined in Canadian law by successive judgments of the Supreme Court since 1990. The court has even ruled that in certain cases, Indigenous peoples will have a right of veto over development of territories or the implementation of projects. For example, in Delgamuukw versus BC, 1997, the court ruled that there is a gradation of engagement with Indigenous peoples in decision-making on their lands once Indigenous title has been established. The court established that there is at least a duty to consult with Indigenous people in all cases. Quote, in most cases, the duty will require much more than mere consultation. Some situations may even require the consent of an Aboriginal nation, most notably where provinces make hunting and fishing regulations on Aboriginal lands. The spectrum from minimal consultation to obtaining the consent of Indigenous peoples has thus been clearly embedded in our regime for 24 years, 10 years before the adoption of the UN Declaration. In another decision, the Supreme Court supplemented this Delgamuukw decision in Haida Nation versus BC, 2004, by clarifying, and this had to do with non-established claims, this time adopting the concept of a spectrum. According to the court, at one end of the spectrum, where the claim to title is weak, the Aboriginal right limited, or potential for infringement minor, we must at least give notice, disclose information, and discuss. At the other end of the spectrum, in cases where a strong prima facie case for the claim is established, the right and potential infringement is of high significance to Aboriginal peoples and the risk of non-compensable damage is high. Consultation may require participation in decision-making, a record of how the arguments of Aboriginal peoples were considered and how they were taken account in the decision. Between these two extremes, the extent of consultation will be determined by the particular circumstances of each case. A duty to accommodate may be required following consultation, where the claim is based on solid evidence and a decision may significantly affect the rights being claimed. The court is careful to point out that this is not a right of veto pending final determination of the claim. Rather, the court accommodation implies seeking compromise with the goal of harmonizing competing interests and continuing on the path of reconciliation, understanding the other's concerns, and responding to them in good faith without the obligation to agree. In closing, Bill C-15 is not a quick fix to over 150 years of systemic discrimination in federal legislation, government programs, and administrative practices. In all cases of discrimination, remedies must be put in place. nor is Bill C-15 intended to make us feel that the future will be easy. The bill is intended to create an obligation for government or governments to develop an action plan. Bill C-15 protects us from the vagaries of government's willingness to ignore known principles which are enumerated in the Declaration. The passage of Bill C-15 is a step in a long journey that began long ago, a step that will allow us to better measure our commitment to advancing reconciliation and our commitment to restoring the trust of Indigenous peoples in the transformation of their relationship with the Canadian state. Thank you, Senator Dupuis.